That sounds like a really good deal. But I think I got a better one. How about I give you the finger, and you give me my phone call?
Oh, Mr. Anderson. You disappoint me.
You can't scare me with this Gestapo crap. I know my rights. I want my phone call.
Tell me.
Now we are going to review the public law section and discover what it had to say about the Privacy Act. As again I'll say, the public law is the congressional records of the hearings that were held on the right to privacy issue. Located on page 6929 under General Statements, it says, the premise underlying this legislation is that good government and efficient management require that basic principles of privacy, confidentiality, and due process must apply to all personal information programs and practices of the federal government, and should apply to those of state and local government, as well as to those of the organizations, agencies, and institutions of the private sector. Next, on page 6932, under Coverage, Private, State, and Local, it states, as reported, the bill applies to federal personal information systems, whether automated or manual, and to those of state, local, and private organizations which are specifically created or substantially altered through grant, contract, or agreement. Those three are very important. We'll cover them in just a second. With federal agencies, where the agency causes provisions of the Act to be applied to such systems or relevant proportions. As introduced in this Bill 3418, applied to all government and private organizations in a personal information system under supervision of a strong regulatory body with provisions for delegating power to state instrumentalities. Now, back to the section where it says grant, contract, or agreement. What private organization will be substantially altered through a grant, contract, or agreement with federal agencies? That would be their business license to engage in a commercial activity within the jurisdiction of the state. To do what? To collect a purported tax from the consumer. Are you understanding how this works? Next, this is also dealing with Social Security numbers and identifiers found on page 6943. Let's review what it says. As introduced in Bill 3418, made it unlawful for any person to require an individual to disclose or furnish his Social Security account number for any purpose in connection with any business transaction or commercial or other activity, or to refuse to extend credit, or to make a loan, or to enter into any other business transaction or commercial relationship with any individual because of refusal to disclose or furnish the number, unless the disclosure or furnishing of the number was specifically required by federal law. That section refers back to the annotation, which would have been section 2B. The committee considers this usage of the number of a government file one of the most serious manifestations of privacy concerns in the nation. However, it received conflicting evidence about the effects of this section, particularly the inordinate cost of the federal government and private businesses of changing to another identifier and reprogramming computers and re-indexing files. Next, we're going to cover page 6944. In recent years, the Social Security number has been the identifier most used in common by government agencies and private organizations to improve efficiency of services, aid management functionings, prevent fraud, and reduce errors in identifying a people. Citizens' complaints to Congress and the findings of several expert study groups have illustrated a common belief that a threat to the individual privacy and confidentiality of information is posed by such practices. The concern goes both to the development of one common number to label a person throughout society and to the fact that the symbol most in demand is the Social Security number, the key to one government dossier. A major concern is the possibility that the number may become a means of violating civil liberties by easing the way for intelligence and surveillance use of the number for indexing or locating the person. A cross-section of such complaints appeared in the subcommittee hearings shows that people are pressured in the private sector to surrender their numbers in order to get telephones, to check out books in university libraries, to get checks cashed, to vote, to obtain driver's licenses, to be considered for bank loans, and many other benefits, rights, and privileges. In many cases, in the private sector, he is informed that the number is necessary for identification purposes, yet on the face of the Social Security card states that it is not to be used for identification. That's also very important. We'll cover that here in a minute. This Prevost was intentionally included in the Social Security program to prevent reliance on the card for identification, because a person could acquire several of them under several identities, and there frequently was no agency investigation of the information provided in order to obtain a number. Now, any Social Security card that was printed before 1974 did have at the bottom that it was not to be used for identification purposes. However, after 1974, after the creation of the Privacy Act, it was taken off there. It was left up to the individual citizen to know and understand what your rights were concerning this information. If you did not know what your rights were, then guess what? Have you ever had a judge tell you that ignorance of the law is no excuse? I have. Next, we're going to cover, under the Public Law 93-579, we're going to cover page 6945, and it states, while specific laws mandate or have been interpreted to permit the use of the number in a few federal programs, most agencies have proceeded to use it by regulation or directive. Executive Order 9397 of 1943 found it desirable in the interest of economy and orderly administration of the federal government move toward the use of a single unduplicated number identifying systems of accounts, and order that any federal department, establishment, or agency shall, whenever the head thereof find it advisable, to establish a new system of permanent account numbers pertaining to individual persons, utilize exclusively the Social Security account number. Keep in mind now, an executive order is not a federal statute, okay? An executive order is a decree from the president. It's a lot like Caesar. Caesar's ruling over Rome. Caesar decrees that we're going to do this today. Well, last time I checked, Caesar was not in power. We still had some semblance of a democracy.